Today we will see the question paper and answers of Civil Judge Preliminary Exam 2012. So friends, watch our complete video, like it, share it, comment on it and don't forget to subscribe our channel. Friends, question number 1. Summons of court can be served by. The answer is any of them, means only a police officer, an officer of the court and public servant. Question number 2. Under Code of Criminal Procedure, substituted service of summons can be made. The answer is by affixing summons on the house. Question number 3. Under Section 97 of Code of Criminal Procedure, search warrant to find out a person can be issued if. The answer is the person is unlawfully confined. Question number 4. Under Section 107 of Code of Criminal Procedure, executive magistrate can obtain bond from a person if. The answer is the person is likely to commit a breach of peace. Question number 5. A divorced wife is entitled to maintenance from her husband. The answer is till she remarries. Question number 6. Executive magistrate can put a party in possession of immovable property. The answer is upon the police report that a dispute in respect of such property is likely to disturb public peace. Question number 7. In a private complaint, case process can be issued against an accused after. The answer is the magistrate is of the opinion that there is sufficient ground to proceed with the case. Question number 8. Any defect in charge, the answer is can be cured by amending it with a direction to retrial if such amendment is causing prejudice to the accused. Question number 9. The statement of an accused is recorded. The answer is to enable him to explain circumstances appearing in the evidence against him. Question number 10. The court on application for plea bargaining by the accused to satisfy itself that it is made voluntarily. The answer is examines him in camera. Question number 11. Decree means. The answer is formal expression of the court of an adjudication determining the rights of the parties. Question number 12. Judgment means. The answer is statement of the judges on the ground of decree or order. Question number 13. If objection to the jurisdiction of the court is taken at the hearing of any application for interim relief, the court shall proceed to. The answer is to determine issue as to the jurisdiction. Question number 14. Res judicata means. The answer is not trying the suit if suit involving similar issues between similar parties is decided. Question number 15. Objection to the territorial jurisdiction of a court can be allowed if it is raised. The answer is at the earliest possible opportunity and before issues are settled. Question number 16. In case of a decree for the payment of money, the court can order interest at the rate of. The answer is 6% per annum. Question number 17. Under the inherent powers of the civil court, it can pass orders. The answer is necessary for the ends of justice or to prevent abuse of process of the court. Question number 18. Defendant can claim temporary injunction in a suit filed by the plaintiff. The answer is to prevent the suit property being alienated or damaged. Question number 19. The defendant shall present his written statement within blank space days from the service of summons upon him. The answer is 30 days. Question number 20. Where any period is fixed or granted by the court for doing an act prescribed by the Code of Civil Procedure, the court may enlarge such period. The answer is not exceeding 30 days in total. Question number 21. Where a 30 years old document is produced before the court, it may presume. The answer is that the document is duly executed. Question number 22. a document can be proved? The answer is by examining the person in whose handwriting the document is written or signed. Question number 23. A confessional statement made before police. The answer is admissible only if it relates to a fact discovered in consequence of it. Question number 24. Admission is, the answer is not a conclusive proof but operates only as estoppel. Question number 25. Admission means, the answer is statement suggesting inference as to any fact in issue. Question number 26. A fact is relevant. The answer is if it is connected with a fact in issue so as to form part of the same transaction. Question number 27. A fact is said to be proved. The answer is if its existence is so probable that prudent man would accept it as existing. Question number 28. Evidence means and includes. The answer is statements of witnesses required to be made before the court. Question number 29. Primary evidence of a document means. The answer is document itself. Question number 30. A child born out of valid marriage can be proved to be legitimate child of the husband if it is born within of its dissolution. The answer is 280 days. Question number 31. Which of these cannot be lawfully transferred as per Transfer of Property Act? The answer is salary of public officer. Question number 32. As per Section 6 of Transfer of Property Act, an easement be transferred apart from the dominant heritage. The answer is cannot. Question number 33. Which of these is immovable property as per the provisions of Transfer of Property Act? The answer is fruit trees. Question number 34. The term transfer under the Transfer of Property Act refers to. The answer is both 1 and 2 are correct. Means partly or whole transfer. Number 2, absolute or conditional transfer. Question number 35. As per Section 9 of Transfer of Property Act, oral transfer are. The answer is conditionally valid. Question number 36. Under the provisions of Transfer of Property Act, the unborn child acquires vested interest. The answer is upon his birth. Question number 37. The mortgage in which, without delivering possession of mortgage property, the mortgager binds himself personally to pay the mortgage money is known as. The answer is simple mortgage. Question number 38. The gift of future property is. The answer is void. Question number 39. The rule of lease pendens applies when the suit in which right to immovable property. The answer is pending between two persons and one of them sells property. Question number 40. The rule against perpetuity prescribes that. The answer is no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living on the date of such transfer. Question number 41. If a contract comprises an agreement to do an act and also not to do certain acts, the answer is injunction can be granted to compel performance of both or any of them. Question number 42. A suit for recovery of possession based on the previous possession of a person can be filed by such person even against real owner of that property who has dispossessed him. Answer is within 6 months of his disposition. Question number 43. A suit for specific performance of contract for its enforcement can be decreed when. Answer is there exists no standard for ascertaining the actual damage caused by the non-performance of it. Question number 44. A court may not exercise its discretion to decree specific performance of a contract when. The answer is The contract gives the plaintiff an unfair advantage over the defendant. Question number 45. A suit for rescission of contract by any person having interest in it can be decreed in his favor. The answer is where the contract is voidable at the option of plaintiff. Question number 46. No court shall declare that the plaintiff is entitled to a right. The answer is if he is able to seek further relief than mere declaration but omits to do so. Question number 47. A perpetual injunction is granted to the plaintiff. The answer is to prevent a breach of an obligation existing in his favor. Question number 48. In a suit for perpetual or mandatory injunction, the answer is plaintiff can be granted damages if claimed specifically by him. Question number 49. In a suit for specific performance of a contract where earnest money is paid by the plaintiff, the answer is it can be refunded only if it is specifically claimed. Question number 50. To claim specific performance of a contract, the answer is necessary to plead and prove that the plaintiff has always been ready and willing to perform his part of contract. Question number 51. Person in occupation of premises is tenant if the answer is he is put in exclusive possession of it and pays rent. Question number 52. A landlord shall not be entitled to recovery of possession so long as the tenant, the answer is pays rent and permits increases and observes the terms and conditions of the tenancy. Question number 53. A tenant cannot be evicted even if he erects a permanent structure. The answer is if landlord consents to it in writing. Question number 54. Premises let to banks or public sector undertakings having paid up share capital of rupees dash dash are exempted from protection of Maharashtra Rent Control Act. The answer is 1 crore. Question number 55. No decree can be passed against a tenant for the requirement of premises for landlord unless the answer is landlord bona fide claims it and is likely to suffer greater hardship. Question number 56. A landlord can get possession of premises for its demolition and construction of new building only if the answer is all the above, means landlord has sufficient funds with him for it, he has approved plan and estimates, and landlord undertakes to provide new premises equal in carpet area of the existing one. Question number 57. A proceeding to recover possession of premises from a licensee is to be filed in. The answer is the court of competent authority appointed by the state government under the MRC Act. Question number 58. If a landlord withholds any essential supply or service to the tenanted premises, the tenant can seek remedy by way of. The answer is application for restoration in the small cause or civil court. Question number 59. Whether appeal against the decision in appeal or appellate bench of small cause court or district court would lie before. The answer is no appeal lies. Question number 60. If the landlord fails to keep the premises in good and tenantable repairs, the proper remedy for tenant is. The answer is to make such repairs himself after 15 days notice to the landlord. Question number 61. If sufficient cause is made out, the time for filing proceeding in the court can be extended if. The answer is the delay is for presenting the appeal or application under CPC. Question number 62. If a cause of action for the suit arises when the plaintiff is minor, he may institute the suit. The answer is within the period of prescribed by limitation for such suit after he attains majority. Question number 63. In computing the period of limitation for any suit, appeal or application, the day from which such period is to be reckoned, the answer is shall be excluded. Question number 64. While computing the period of limitation of a suit time spent in another similar proceeding in the court having no jurisdiction can be excluded if the answer is the plaintiff had acted in good faith with due diligence. Question number 65. A suit can be said to be in limitation even after period prescribed. The answer is if the defendant acknowledges liability of the plaintiff's right before expiration of the period of limitation. Question number 66. When a new defendant is added in the suit shall be deemed to have been instituted against him from. The answer is the date of his addition. Question number 67. In case of an easement by prescription, the period of 20 years must be ending within dash dash from the date of institution of the suit. The answer is 2 years. Question number 68. Suit on a bill of exchange on promissory note payable at a fixed time should be filed within 3 years from. The answer is the date on which time expires. Question number 69. A suit for possession of immovable property based on title can be brought within 12 years from. The answer is the date on which possession of defendant becomes adverse. Question number 70. Where no period of limitation is prescribed for an application, it can be filed within. The answer is 3 years. Question number 71. An ordinance can be issued by the President at any time when. The answer is both the houses of Parliament are not in session. Question number 72. The proposal to prefer charge against the President of India should be moved by at least dash dash of the total number of members of the House. The answer is 1/4. Question number 73. Article 14 of the Indian Constitution does not prohibit. The answer is reasonable classification. Question number 74. Under Article 356, a proclamation to remain operative must be approved within 2 months by. The answer is both the Houses of Parliament. Question number 75. Who presides over the meeting of Lok Sabha in the absence of the Speaker? The answer is Deputy Speaker. Question number 76. Which of the following fundamental rights is available to both the citizens and non-citizens? The answer is the right to equality before law. Question number 77. Who appoints Attorney General of India? The answer is President. Question number 78. Who can issue a writ for the enforcement of legal right? The answer is High Court. Question number 79. Judges of the Supreme Court other than the Chief Justice of Supreme Court are appointed by. The answer is the President in consultation with the Chief Justice of India. Question number 80. In case there is a conflict between the preamble and other provisions of the Constitution, which will prevail over the other? The answer is preamble will prevail. Question number 81. Essential ingredients of the offense of mischief is. The answer is intentionally causing wrongful loss or damage to the property of another by destroying or diminishing its value. Question number 82. If a person entrusted with a property dishonestly converts it to his own use, he commits. The answer is criminal breach of trust. Question number 83. When by putting any person in fear of injury, he is dishonestly induced by another to deliver property, it is. The answer is extortion. Question number 84. Theft is committed when. The answer is a movable property is taken away secretly without consent of its owner. Question number 85. Grievous hurt means. The answer is any hurt which endangers life. Question number 86. Unlawful assembly means. The answer is an assembly of 5 or more persons having common object to commit offense. Question number 87. Criminal conspiracy means. The answer is agreement between 2 persons for doing an illegal act. Question number 88. If a person instigates, intentionally aids or engages another person to do a thing he is said to have? The answer is abated such another person. Question number 89. When a person gains something by unlawful means to which he is not legally entitled, it is. The answer is wrongful gain. Question number 90. Culpable homicide means. The answer is causing death intentionally. Question number 91. A suit involving unregistered partnership arising from a right from a contract of such partnership is maintainable. The answer is if it is filed by the legal heirs of deceased partner for accounts of such firm. Question number 92. Partnership firm. The answer is not a legal entity. Question number 93. Partnership means. The answer is agreement between the persons to share the profit of a business carried on between them. Question number 94. An agreement is void if. The answer is if its object is unlawful. Question number 95. Agreement to do impossible act is. The answer is void. Question number 96 is cancelled. Question number 97. A contract between an insurance company and vehicle owner to save the latter from consequences of a vehicular accident is a contract of. The answer is indemnity. Question number 98. Delivery of goods is deemed to have been accepted by the buyer when. The answer is intimation of their acceptance is sent by him. Question number 99. A contract of sale of goods is a contract whereby. The answer is the seller transfers or agrees to transfer the property in goods to the buyer for a price. Question number 100. Unpaid seller means. The answer is a seller who is not paid or tendered whole of the price agreed.